And anybody who has a question at the end, just or during the presentation, give it to Kelly or Josh. These are my office staff that are here today, and then they'll bring them up to me so that I can try to answer them at the end. If anybody needs any handouts, anybody who just came in, just hold your hand up, and we'll provide one to you. So it's just after 2 o'clock, so I would like to please get started. And if you follow along on the one-page, one-sheet, double-spaced handout, I have tried over the last 20-plus years to not overload people with a lot of facts and figures and regulations and statutes, but to try to make the presentation about Medicaid asset protection and estate planning as simple and as clear as possible. And anybody who has any more intricate or more involved questions, I'm happy will be here at the end, me and my office staff, to answer those questions. First of all, just a few very important housekeeping items. I would like to very much extend my appreciation to the entire Achiezer organization. This is my fifth time that I'm presenting with them. We haven't missed one from the get-go, and it's been about 10 years. And really from Rabbi Bender and Milka Kielsen, and not to omit anybody, but I would be here all day, really the tremendous job that it took to put this together and all the other amazing things that Achiezer does. So the other item that I wanted to mention is that today with me, perfect timing, Josh Kurtz, my associate attorney, and remaining seated, Kelly Martinez, my paralegal of over 20 years. I think it's 22 years now. And we have a pretty small family to help your families out. We don't have a lot of extra layers of departments and extra personnel and staff. So usually if you have a question, you're going to get one of us. Preferably me. If I'm not available, then it'll be somebody else. So the people who are here today, this is my office. Okay, so let's go right into and talk about what it means to do any asset protection and estate plan. From our perspective today, I'm a certified elder law attorney, and I basically represent seniors and their families. So we do a lot of help for people in their 20s and 30s and 40s, but they have very different issues than our family members and loved ones who are in their 50s, 60s, up until their 90s. I mean, we have some clients who are over 100 years old because sometimes issues come up and families need help. So in the first area called Asset Protection and Estate Planning Documents, I have listed advance directives. Advance directives are legal documents that many of you in here may already be familiar with. And these documents enable other family members or trusted individuals to help out, assist, and make decisions on your or another person's behalf when you're unable to do so. So let's go through those documents. The first document is a power of attorney. These documents are what I consider to be foundational items. If you don't have these documents, it's really very hard to have a discussion about more advanced items, like items that appear further down on the list, like trusts and Medicaid. Because if you don't have a power of attorney, and I don't even mean necessarily for yourself, if it's applicable, yes, but on behalf of a parent or a spouse, because if you could be married for 50 years, but if you don't have a power of attorney, you're not going to be able to do a lot of things on behalf of your spouse. People say, wait, but we're joint on all the accounts. I go, right, you're not joint on the IRA, because that's just for an individual person. So there are many, many examples of things that can come up why, even if you're married for many, many years, you're my only daughter, my only child, you still can't automatically act on behalf of that parent without having the appropriate legal documentation. So that's a power of attorney. Now, to say you need a power of attorney is very general. It's very general. It's like saying, I want a dish of ice cream. Okay, well, I know what ice cream is, but do you want vanilla? Do you want strawberry? Maybe you want something interesting like pistachio. Well, powers of attorney are like that also. You can have a statutory short form power of attorney. You can have a springing power of attorney that takes effect later on if a person becomes incapacitated, or the ones that elder care attorneys typically advise is a statutory general durable power of attorney. Now, that's a mouthful, but we just say power of attorney. But again, people come to me and say, oh, I have a power of attorney. Okay, let me see it. And it's a power of attorney that they did at Apple Savings Bank. Well, the Apple Savings Bank power of attorney form is going to be useless for any other legal aspect or work that needs to be done other than at Apple Savings Bank. So a general durable power of attorney is much more expansive. It covers virtually every conceivable event that can occur. What does durable mean? Durable means that even in the event that a health crisis ensues and a person loses their capacity, well, nevertheless, that power of attorney is still going to be effective. It's not simple because other powers of attorney are not going to remain effective if the principal, that's the person who creates the power of attorney, is no longer competent. So these are the issues that we care about, and especially when we're talking about our older loved ones and seniors or ourselves, that infirmity or incapacity could come into being. If a person doesn't have a power of attorney, is all hope lost? No. But they may wish that it was like that because they would then have to go to court. They would have to commence a guardianship proceeding. It's very expensive. It's very time-consuming. It's very stressful. You have to go to a judge, and they appoint a court evaluator and a court examiner, all because I didn't have this document where I said, I name my husband, I name my daughter, I name my wife, my sister, whatever it is. So advanced planning documents are documents that you put into place in advance of a situation occurring, usually some type of debilitating event. As long as you're okay, the power of attorney doesn't really have to do anything on your behalf. If you're okay, and the power of attorney understands that you're still making decisions for yourself, then the power of attorney should not overstep their authority. So we have a lot of questions like that, and people come in and they want to know, my son, he started doing this, and it's against my wishes. So we have to have a meeting with the son. We have to straighten things out. It always has to be that the parents' wishes are followed. It's not for me. It's not what I want. It's not what, the kids want. It has to be for the parent. Okay. Just like there's a document for legal and financial decision making, there is also a document for medical decision making. And those are healthcare proxies. A healthcare proxy is a document where somebody appoints another individual or backup individuals to make decisions on my behalf if I'm unable to do so for medical purposes. Now, I'm not going to get into the full details about it, but because we are dealing with especially the Achiezer Jewish Healthcare Expo, as opposed to me being in the St. Francis Library, it's a little different. So when it comes to halachic documents and medical documents, which we help families prepare as well, so that's a different type of idea where somebody says, I want to also set forth that my wishes are to always be dealt with and treated in accordance with Orthodox Jewish halacha. Okay? So I'm not a Rav, I'm not a posek, but of course we're able to utilize, and we've been helping families for over 20 years, set up this type of an arrangement so that the documents, and they could list a rabbi, they could list an institution of higher learning. People have different arrangements, But it's enough to say that we're able to help get what are called halachic medical proxies or halachic living wills. A standard living will, what we call non-sectarian, not Jewish or not anything, is a document that has to do with, and here's a little bit of a tough subject, end-of-life decision-making. So a medical proxy can make any decision on behalf of someone else if that person is incapable of making their own decisions, except one, and that is the decision to withhold or withdraw artificial life support, unless you have clear and convincing proof that the person says, I don't want to be kept on machines, I don't want them to do experiments and pumps and tubes and respirators and all different things. I'm not a doctor, I'm not a rabbi, but this is what's going on in the world, in outside, and people have a lot of concerns about this, so we're able to do a good job of ensuring that your wishes, the family's wishes, are followed. Those documents, I always put at the top of any speaking engagement or presentation that I have. I always start off with advanced directives, because I think it should be patently obvious that if you don't have the authority to act on behalf of someone else, we're going to end up maybe even starting a project or starting a plan and then getting frustrated in between. So foundational items, general durable powers of attorney, healthcare proxy and a living will, halachic or standard, those are the groundwork items that we want to make sure that all of our clients and their families have. Let's switch a little bit now to post-mortem. What happens after a person passes on? Well, a last will and testament is a legal document that a person prepares or has prepared for them that says a number of things. This is very common, nothing really earth-shattering here. It's very important that a person take control. You have an achrayus, you have a responsibility not to leave things, mysterious. We don't know. I'm nervous. I don't need a will. Just so that there shouldn't be any type of disagreement in the future, even though with a will there could be disagreement. But with a will, you're setting forth what your wishes are about who you want to name as your executor or executors, and how you want your estate to be handled. Again, we get into halachic issues sometimes versus, let's say, just legal or non-halachic situations. So we can help families out in that regard as well. But the will is a document that, after a person dies, takes effect. A will really has no legal relevance while the person is still alive, because it's a statement about what should occur in the future when I pass away. I could change it until the day before I check out. I could change my will. So a will doesn't really have any lifetime effect. Nobody has any type of rights or any type of claim because, it says in the will that I'm going to be this. Okay, got it. So a will is something that does come into play very much so in any estate plan, because it's saying what I want to happen with my estate. But I'm going to now go right into the living trusts section right below, because the living trust, and as you may be able to differentiate, and for anybody who took high school Latin, I put in parentheses in italics the words inter vivos. Inter vivos means during life. B'chaim, while I'm alive. Oh, so this is already very different than a will. I just told you that the will only takes effect when the person is not here anymore. But a trust, that already has chios, that already has import and value now, when I'm alive, when I set this up. What is a trust? A trust is an agreement. It's an agreement between the person creating the trust, let's say the mother, and the trustees, let's say the daughter and the son. Then whatever we put into that trust agreement is what counts the most. The number one reason that families have been coming to us for over 25 years when they want to set up a trust is in order to shelter and protect their assets. So if you see under the Living Trust section heading, I have two very brief entries, revocable and irrevocable. There are a couple of chairs up here if anybody would like, by all means. Revocable and irrevocable. Irrevocable, I'll get to in a moment, to be differentiated from revocable. I can create the trust on a Tuesday, and a week later I can change my mind and change the trust, break the trust, dissolve it, or revoke it. So those types of trusts have a lot of value and benefit, mainly in the context of avoiding probate. So when a person has a will, just be careful. Watch, there's a light stand over there, sir. Somebody want to give a hand? Is there a lighting guy? Or? Oh, good, perfect, thank you. A revocable trust, the primary purpose is in order to avoid probate. See, when a person, let's take an easy asset, has a house or a bank account that's just in their name alone. It's not joint, it's not held ITF, in trust for, POD, payable on death. Person has a bank account just in their name. No designated beneficiary. Okay, I think I made the point. Just in their name. And that bank account is $75,000, making up a number. When that person dies, in order for her family members to inherit that $75,000 bank account, they will have to go to court, take the will to surrogates court. They hire a lawyer, generally, although they don't have to, but they would hire a lawyer, and they would fill out a petition, they would fill out a decree, they would fill out all sorts of oaths and designations and affidavits. You have to serve all the relatives. And then if everything is good, the judge goes, approved. Now you're the executor. And now you have to go ahead and do this. With a will, a lot of people say, oh no, it says in the will, my kids. Right, but if it's going through the will, we need a judicial figure, a judge, an authority, to authenticate the will and make sure everything is good, because there's a lot of mistakes, we'll call them, that happen in the Welt. So that's with a will. So now a lot of people come to me and they say, oh, I thought that if I have a will, I don't have to worry about anything. Well, as long as you don't mind going through that rigmarole that I just mentioned. It could take longer. Queens County, sometimes it's 6 months, sometimes it's 3 months to get it done. Sometimes it could be a year if there's problems, if there's a fight, but the son doesn't want to sign the papers. Okay. All of that is with a will. But when you have a trust, and you put the house in the trust, you put the bank account in the trust, now you don't have to go to court because you avoid probate. Why? What's the logic behind it? The logic behind it is that you have already set forth, while you're alive, what is going to happen with those assets by putting them into your living trust. So while I'm alive, I already did this, and it will therefore avoid probate. So remember, I'm still mainly talking about a revocable trust. Okay? What's the difference now between revocable and irrevocable that matters for our asset protection planning? Because I told you, when it's in a revocable trust, you can change it, you can break it, you can revoke it, in, out, whatever you want. It's revocable. So if somebody, Khalila, got sick and they needed home care, or they needed special services, or they needed a nursing home with Medicaid, whatever it may be, well, now the assets that are in their name alone are exposed and are subject to whatever that person's problems may be. So we don't want it to be a revocable trust. Rather, instead, we want it to be an irrevocable trust. Irrevocable means I set it up on a Tuesday and I can't really change it the next week, the next month, or the next year. In some special instances, we are able to do some changes, but I tell people if you're setting up this trust, the purpose is to protect your assets, to shelter your estate. So we don't really ever want to treat an irrevocable trust like a piggy bank, like a cookie jar, where you put money in, you take it out. That will diminish and dilute the benefits, the protection of the trust. So an irrevocable asset protection, and you see I put the word Medicaid in parentheses squashed in there, planning trust, is protected. So if a person needs to go on any type of long-term health care, I now segue into part 2, paying for long-term health care. They have only a few options available to pay for their care. So Medicare and HMOs provide very brief, long-term coverage. I am forever advising people and informing them that Medicare covers medical care. HMOs pay for medical care. We're talking about long-term health care. It's not provided by a doctor. It's not provided by a nurse. It's generally provided, if it's in a nursing home, by the nursing facility, or if it's in a home care setting, then it's provided for by home health care attendants or a PCA, things like that. And that has very, very limited coverage by Medicare or HMOs. The other way to pay for that type of long-term care is private pay, right? And that's very expensive. We know what costs are in a good glatt kosher nursing home. 1 month, $15,000 cash is about right. It could be more with a couple of extras and goodies. Home health care for 24/7 care could be about half of that. It could be $8,000 or $9,000 cash. So private pay is the second way to pay, is the first way to pay for long-term care in a long-term situation, and the next one is long-term care insurance. So long-term care insurance is also very expensive, and we see a lot of people coming to us and they got a plan 10 years ago, but it doesn't have really great coverage now. Maybe they have $250 a day, which is pretty good for home care, but in the nursing home setting, they're running not even 50%. So that means that there would be some depletion of their assets. So long-term care coverage is very good. It has to be affordable. You have to be able to qualify for it medically. However, it also has to really give a good amount of coverage. Otherwise, there could be a shortfall in the family's planning for asset protection. Which now gets us to the biggest and number one method of paying for long-term care. And this is either home care or in a nursing home. Whether it's in one location or the other, Medicaid will cover those services. Not Medicare, Medicaid. So Medicaid will pay for almost all of the costs associated with caring for a loved one either at home or in a nursing home type setting. The number one question I get in my practice, we hear this all the time, is, I have too much money, I can never qualify for Medicaid. Or, I have too much monthly income, I can never qualify for Medicaid. Isn't that right, Mr. Spirn? I say no. I don't believe that's correct. We need to analyze. We need to look over the situation and understand. But there are people who come to us with $1 million house, and they're not millionaires. They just happen to buy on East 12th Street in Flatbush 50 years ago for maybe $39,000, and now they're getting people knocking on their door for $1.4 million. Okay. So, but they're not millionaires. They can't go to Glot Mart or to Gourmet Glot and buy groceries. I can't go to Aaron's Casino Farms and say, oh, I have $1 million house. Give me groceries. No, they're going to say, get out of here. You got to pay for that. So they have that asset, and boy, oh, would the city love to get their hands on that type of an asset. The city is the biggest property owner in New York City, because a lot of people go on programs and they don't realize they own the property. And then when the person passes away, the family gets a claim letter for estate recovery. But we'll talk a little bit more about that after. So, yes, it's absolutely possible to qualify for Medicaid benefits if a person gets their assets down to about $15,000. So if a person, I meant to tell you, they have that $1 million house, and then they also have, let's say, $200,000 in savings or in investment money. How do I get down to $15,000? A lot of people think you have to spend that money down and get rid of it. That is not the law. The law says that you can take that money and you could put it into a trust, or property or house. You could put it into a trust, and when you get down to $15,000, we can get you Medicaid home care services 1 month later, 2 months later. People are astounded. They go, no, somebody told me in shul, that's not true, or I was at the library, and no, I was online in the supermarket. I go, look, I'm just telling you how it works. So it definitely pays to be knowledgeable and to avail yourselves of the correct information. So we help families with a lot more money than that become eligible. Nah, I don't want, you're ripping off the government, you're gaming the system. I go, I'm not gaming anybody, because this is what the law provides. You don't want to do it? Gesundheit. Spend your Yerusha, spend your money, and then guess what? When all your money's gone, you'll have to go on Medicaid anyway. So what's the chilek? So you might as well go ahead. Don't be such a chacham from the Manashan. And you say, hey, let me do it the right way. The law, since 1993, provides you can set up a trust. You can put your assets into the trust. New York State is a very, very generous and liberal jurisdiction. So it's very, very doable. It's a very big kenzain. It's very possible that you're able to do this and still get the benefits that you need. What about my income? Income, Medicaid says if you're only allowed to have $15,000 or so, I'm using round figures for today's purposes, not to impress upon you too much. I could only have $15,000 in assets. What about income? Income, I can only have $879 a month. Okay. But I get Social Security and I get money from my pension. So I'm getting $3,400 a month. What's going to happen? Can I get Medicaid? Yes, you can get Medicaid. But we have to do something with the excess income. And you can set up a pooled income trust. There are people here today who are representing a lot of the vendors. Everything I'm talking about, people here, Achiezer is helping to direct families to, and there are solutions for all of this. That's why we're all here together today for you. So you get a pooled income trust. Well, does the pooled income trust take away my money? No, they don't take away money. They go ahead and they take the excess money, right? Now you're eligible for the Medicaid services, and you direct them what bills to pay. What kind of bills? You name it. Anything. real estate taxes, rent in an apartment, co-op maintenance fees. What about for grocery? What about we get takeout? We don't you can take takeout, Gesundheit, whatever you want. A cleaning lady, you want to go to the movie, whatever it is, as long as it's for you or the person who's going on Medicaid, you got it. So now we're taking your excess monthly income, which, by the way, if you get onto the George Washington Bridge and you go into New Jersey says no. If you're over, New Jersey is an income cap state. If you're over the federal allowable limit, it's a knockout. New York is one of very, very few jurisdictions that say you can set up a pooled income trust and you can spend down. So there definitely is very good solutions and good aids for people who have assets, and they work their whole lives, and they have a retirement, and there's income coming in and things like that. I also have listed over here, I want to talk about spousal refusal, which even enables one spouse to have assets above the limit and then still qualify for Medicaid. Again, New York State allows spousal refusal. So if we have a husband and wife, and let's say the husband needs a Medicaid care, either in a nursing home or at home, the wife is allowed to have, let's say, between $75,000 and $100,000 clean, protected in her name. Okay. Of course, we advise setting up a protection plan and with a trust so that it's all there and preserved for the husband and the wife, the parents. But even so, spousal refusal says you can go ahead and you can keep your assets and you can keep your income spouse who doesn't need Medicaid, what we call a community spouse, and still, this gives tremendous peace of mind, the menuchas hanefesh, the people who are concerned, I'm not going to have money, how am I going to survive? So there are allowable rules that help people out. I wanted to mention that Holocaust reparations funds that people have coming in are also another type of exempt income or resource, as long as it's set up in a proper way. If it's mixed in with the Social Security and if it's mixed in with your other finances, then it can lose, the parents' Holocaust reparations funds can lose their exempt status. So we want to pay attention to this. And when we sit down with a family, we want to make sure that everything is beseder. We've had families come in and we figured out, because they were getting either from claims conference or Vita Gutmach, that they got $190,000 of Holocaust reparations over the last 26 years. I go, okay, where are the, I put it in with my other funds. And I go, well, I'm just telling you that if it's mixed in with those other funds, then you're going to have a problem. No problem. Okay, so we want to make sure that those funds are not commingled. And there are other exceptions as well. Part 3, real estate. So as I've already alluded to, so I don't have to spend a lot of time on this point again, generally the most valuable asset that a family has is their home, because they bought it so many years ago, whether it's in Flatbush or whether it's in the Five Towns or whether it's in Queens, it doesn't matter. It has typically risen tremendously in value. So we can put the property either in a life estate or in a trust. A life estate isn't really the greatest way of going, because it does limit the options going down the road. But if it's appropriate, sometimes if the child and the parent live together, we can try to do that. And when you put a house into a trust, you're also allowed to sell it in the future. And then those funds are likewise protected. And you could buy another place, protected in the trust. So you probably heard me today mention 24 times that the trust is really the engine and the driving force behind any type of estate and asset protection plan. I want to also talk about, before we go into the Q&A, Part 4, estate administration. I touched upon this a little bit, probate versus administration. So probate is when you have a will. Administration is when a person does not leave a will. And when a person does not leave a will, well, there is a backup set of laws in New York State that do kick in. But that may not be in accordance with what your wishes are. So we're happy to advise you and to talk to you about the differences between probate and administration, and basically what is entailed. But it's definitely preferable to have a will versus not having a will, and it's also even more superior to have a trust in conjunction with, or I don't want to say in place of, but as opposed to a will. Estate taxes, I'm very happy to inform everybody here, unless, are there any Rothschilds or any Rockefellers? Right now, the estate tax laws are unbelievably, I'll say, generous. On the federal level, each individual can pass away with over $11 million estate tax-free. Anybody who's in that category, call me up. I'll give you a free consultation. All right? Okay, New York State. It's about half of that, $5.5 million per person. So that means a couple can pass $10 million, or an individual $5.5 million estate tax-free. So we don't see a lot of estate tax situations anymore. Most of those are migrating into Manhattan, and they want to pay tens of thousands of dollars in lawyers' fees. We help people who are much more modest and on a much more manageable level. Okay, so we have a few more minutes. So I know that we have a few questions that were handed up, if I may. Let's get those. Thank you. The envelopes, please. I gotcha.
I just want to, as this is totally unrehearsed, we'll be ending at 2:45. The vendors are still open until 3 o'clock because there were people here who actually sat like a whole day in high school. Remember that? And we want to give you a chance to see the vendors. There will also be Mincha at 2:45 in that main exhibit room.
Thank you. And I will also be here with the vendors to answer any questions if I don't get to anybody, because we have quite a few. So how much money can someone have while on Medicaid? As I mentioned, a person can have it's actually $15,450 in assets. That's separate from retirement money. And they're allowed to have 879, thank you, Josh Kurtz, Associate Attorney, in monthly income. Can you discuss the 5-year look back, and does it apply to home care? So for nursing home care, there is a 5-year look back and penalty period, which means if a person gave away money, then they have to wait 5 years potentially to qualify for Medicaid nursing home care. But for home care in New York City, even in Nassau County, it's 1 to 2 months. So that's a very, very common concern and question that people have. Good. Next. Does New York Medicaid cover someone in New Jersey? Absolutely not. Once you cross the George Washington Bridge or the Verrazano Bridge, well, not the Verrazano Bridge, but when you go Bayonne Bridge or Outer Bridge Crossing, thank you for my Lakewood people, there's no coverage. There's no coverage. So that does not work. What do we got?
Can I answer that question?
Yes, of course.
Some people's decisions to move into retirement communities in Lakewood.
Absolutely. So that's a very big, I don't want to say a point of contention, but let's face it, a lot of people who live in New York, older people or parents, want to be with their kids in Lakewood or in Teaneck or wherever, in New Jersey. And that definitely adds a wrinkle and a layer of involvement. So we have a very close working relationship with New Jersey elder law counsel in order to do so. There's no way around it. It's New York. It doesn't matter if it's Florida. It doesn't matter if it's Eretz Yisrael. It doesn't matter if it's California. New York is New York. When a person leaves, their benefits no longer continue beyond the jurisdictional boundaries. What does inter vivos mean? Again, that means during lifetime. We set up a trust, it's during our lifetime. Otherwise, a trust could be a testamentary trust, which is set up in my will. What do you mean? A will is a will, a trust is a trust. No, my will says that when I pass away, my son, he doesn't have the best spending habits and he has a bad track record with failed businesses, so I don't want to leave the money to him directly. Rather, I want to leave it in a trust for him, and his uncle is the trustee, or the accountant is the trustee, and that whenever he needs money, it's given to him. Okay, sometimes it could be for spendthrift reasons, sometimes it could be because a family member or a child has special needs and they have any type of exceptional medical circumstances. So you can also set that up. I'm not going to be able to finish. You can also set that up, no problem, in a will that takes effect when a person passes away.
Before you go to the next question, any more questions, write them down, put your email on the bottom, you'll give them to me at the end of the session. We have exactly 2 more minutes for this session. Just want to acknowledge Rabbi Baruch Bender.
Rabbi Bender.
Good job.
No standing O's, just, right, okay.